You're all set. Go ahead.
Good evening to our Land Development Code public outreach meeting. This is for round 2, 2022 Land Development Code text amendments, and I will be sharing the screen. We are going to be presenting 3 items tonight. Okay. Okay, so I am going to start sharing at this moment. So again, this is our public outreach meeting, September 20th, 2022, Land Development Code text amendments, round 2, 2022. The next hearing scheduled for this round will be on September 29th, the first public hearing in front of the Board of County Commissioners. Then on October 10th, it will go for consistency finding, the Planning Commission meeting, and then the adoption meeting will be on October 20th, 2022. 3 items will be presented tonight: rezoning and land use meeting procedures, affordable housing development standards updates, and gopher tortoise habitat text amendment. We're going to be going through each of those, and then we will pause for questions on each of them. The first item, LDC 221113. This amendment is to modify the rezoning and land use meeting procedures, including providing for more expansive record for board consideration and for revised duties and responsibility of the land use hearing officers. It will maintain the zoning hearing master process with established criteria for consent agenda items and provide that the board would hear applications not meeting the criteria for consent agenda. It will also provide for an open period between the zoning hearing master hearing and the board meeting consideration, whereby the record may be supplemented through the submission of additional written or documentary material. There are other changes also included in this text amendment, such as the role and qualification of the hearing officers and the timing of the open record period. And that summarizes this text amendment, and we are available if you have questions or comments.
Diego, with respect to that middle bullet, provide for an open record period between the ZHM hearing and the BOCC consideration, whereby the record may be supplemented. And is there an implied only there through the submission of additional written or documentary materials, which is then in the actual attachment 7 business days before each Tuesday land use meeting? Does that mean that oral testimony is cut off when the zoning hearing master finishes?
Okay.
I think the intent is, and again, based on board discussion, is that there's a clear desire for the board to, with respect to citizens that may show up at the board, we've heard comments about, how the county attorney basis, they start straying from exactly what they said at the ZHM hearing. The county attorney often cuts them off and advises, they can't speak on that. There's a clear desire of the board to allow that kind of verbal interactions to be allowed at the BOCC meeting. The intent of this provision is that if you're going to be submitting any kind of written or documentary evidence, like some reports or something, that you did not submit at the original hearing, that you want to submit for review and consideration, that those kind of documents have to be submitted within that time frame, which is, again, like I said, basically 10 calendar days, 7 business days prior to the BOCC meeting. There's not intent to, basically if someone shows up and begins speaking that was on items that weren't specifically at the ZHM, that to prohibit that from occurring.
Doesn't that handicap the staff and the commissioners regarding the inability of staff to therefore brief the commissioners on new issues, surprises that come along oral instead of written documents?
And obviously, the board, as they do now, certainly has the opportunity, if issues come up, to continue items if they feel the need to, and or remand. So I don't think that changes that ability. So yeah, I think it's just going to be a matter of, seeing how that particular issue works its way through the process and discussions with the board at the board meeting.
Does that invite an inordinate number of continuances, which may kill contracts if you've got a contract deadline by which you have to, close with the seller, or you lose the deal if you don't, finish in time vis-a-vis? And might that create an inordinate inordinate number of occasions for continuances?
Yeah, I guess that's somewhat speculative. I mean, again, I can't speak to what may occur in the future with this. Again, as the way that's been laid out is in accordance with the direction we were receiving the Board of County Commissioners, how they want to establish this revised process. So I understand the concern, and I think that'll just something I'll have to see how that plays out as we go forward, if this is implemented and adopted by the board.
Thank you, Brian, for letting me address those questions, and
Sure.
for being faithful to the commissioners who appear to have sent you some orders that you're just trying to carry out the best you can. And thank Adam for taking my call too. He was very gracious on these legal issues, and answered as you did consistently and what you thought the board needed or wanted.
Thank you.
All right, so we move along to the next item. This one is related to a comprehensive plan amendment. This will revise and add development standards to implement the affordable housing density bonus policies proposed as part of the housing section by the Comp Plan Amendment CPA 22-08. In summary, the requirements of the bonus usage, including affordability term, density, setbacks, and income requirements, will be amended. The usage of this regulation, if adopted, only applies to those properties within the urban service area boundary. Section 61107 of our Land Development Code provides the standards to implement the affordable housing density bonus, and this text amendment will update that section of the code to reflect the changes to the comprehensive plan. And we do have staff from the Planning Commission in case you have comments or questions.
And great ones at that. Were the bus emphasis corridors bonus, density bonuses in the pipeline? Or the bus emphasis corridors density bonuses in the pipeline? I don't see it in this language.
And this is Jay Collins with Planning Commission staff, and I can address that if that's okay, Israel.
Yes. Yeah, thanks, Jay.
Sure, yeah. Mr. Weaver, that amendment is still being processed right now. So obviously, since staff is still working on language for bus emphasis corridors or whatever it may be called, it would be premature for us to actually put any type of language related to bus emphasis corridors or whatever it may be called in the future in the housing section. The idea of the bus emphasis corridors is something that can live in the future land use element. And then if needed, we can have an additional supplemental amendment to provide anything in housing if it is needed or warranted.
How long would that take if we don't put on this train? How many months are we losing to get some density bonuses for at least existing bus emphasis corridors? Is that like a 7 or 10 month delay based on what you said?
There are not bus emphasis corridors currently defined in the comprehensive plan. So it's brand new language that is being undertaken to identify and incentivize, whether it's those corridors or other specific geographic areas defined to be determined. So they're still working on it. The amendment is still there. So I believe, and Alvaro, you may know off the top of your head, I don't. I think they have some meetings and they may have another meeting in front of the board coming up, but I don't have the information in front of me.
Yeah, I can't be of more help there either. I've sort of lost track of the delay with their work. So,
but Ms. Weaver, Katrina Cochran with our agency is the lead on that, and I will let Ms. Cochran know that you were mentioning and asking some questions about it tonight in this meeting.
Thank you. Jake and I did have a couple of questions in the hall this afternoon about that aspect of it. Weren't they traveling together rather well 4 months ago, so they could be finishing together on this train?
Well, one of the items again, and I don't know if Adam is on the call with us. Adam is very interested in the bus emphasis corridors or whatever it may become in the idea of the transfer of development right amendment that the county is working on. And again, that is something that DSD is working towards, and that's Adam is working towards that. I only know that at one time there was the idea of having some synergy between those two, such as the ability for the bus emphasis corridor to have density. It might be something that transfers from other areas of the county, whether rural, environmental, coastal high hazard, into those areas that we've identified to receive, which might be the bus emphasis corridors. So it would be premature for us to run through everything on bus emphasis corridors and not have the TDR component and vice versa.
Thank you. And when it comes back, Jake and I were wondering, and I think he's raised this a time or two over the last few months, the draft that was last before all of us did not get any density for future, which was, I think, in a different shade of green, as I recall, than existing bus emphasis corridors, none whatsoever. And it would seem like to incentivize future bus emphasis corridors, it would seem like there ought to be at least some kind of way to ramp up to it, like half density instead of full density bonus for a legitimately identified future bus emphasis corridor, which, unless identified as such by that lighter green in those maps, would not, enjoy even that half bonus instead of full bonus for density, to try to incentivize future bus corridors, also to get up for the bus to work as far as ridership. Does that make sense on future bus emphasis corridors, getting some at least partial density benefit? And I like the sound of the TDR. That reminds me of an issue that did come up 4 months ago and kind of explains the delay, candidly, is what exactly a lot of the bus emphasis corridors are existing bus emphasis corridors in the other shade of green. The darker shade of green were, in fact, a lot of them were built out. So to transfer density now and to look at the realities of those corridors, I think I understand the delay, and thank you. Thank you, Jay.
Yes, sir, and I'll relate that to Katrina. I just wanted to mention that we all know enough about bus emphasis corridors to be dangerous, but none of us want to get out in front of our skis.
Thank you.
Thank you, Jay. That moves to the last item, LDC 22-1406. This is related to the gopher tortoise habitat text amendment. This amendment will require applicants for development of land that includes gopher tortoise habitat to provide a bird survey prepared by a Florida Fish and Wildlife Conservation Commission staff, authorized agent, and to report any previous violation of gopher tortoise regulations in the state of Florida. It will also provide for consideration of a smaller lot size requirements for development that preserve on-site significant wildlife habitat beyond the minimum required by the Land Development Code. And it will also increase penalties for unpermitted land alterations significant to wildlife habitat. This will include changes to Part 401, Natural Resources, also 503, changes to plan development, Section 601, District Performance and Standard for the lot development size changes, and also Part 1106 enforcement. This amendment is also related to a Comprehensive Plan Amendment 22-15 of the Comprehensive Plan. That concludes this presentation.
Did anybody ever answer John Goolsby's question a week or so ago about whether or not the magnitude of that habitat was going to be the subject of some staff are saying, oh, I think it is, instead of it being subject to study by the applicant or by any agency on whether or not it is or is not habitat? Since I think the answer from staff was, well, a lot of the county isn't mapped on the subject, which doesn't answer my question, whether or not that means staff could say, I think it might be, instead of it being already mapped, since most of the county is not mapped, does that mean that you're going to have expensive studies by applicants on what is and is not the habitat that's protected? And if just curious what Goolsby had that question earlier in the week.
Yeah, and Ron, this is Adam Gormley. I'm on the phone, so I don't have the visual. But the intent with this amendment is to have it applied to mapped significant wildlife habitat into land that functions as significant wildlife habitat, whether it's mapped or not. And
Thank you.
um,
Good answer.
yeah.
Thank you, Adam. I have no more questions, and thank you all.
Thank you.
All right, thank you, Adam.
Somewhere.
All right, so that concludes our presentation tonight. Only 3 items. And if there is no more questions, we may adjourn
Thank you.
this meeting. Thank you, everybody.
Thank you.
Have a good night.
Thank you.
Good night.